Let's talk about the two ways to start the patent process for getting a utility patent and why one of these is going to be the preferred method for startups. At least that's how I almost always start with startups. So the first one, and this is the first line here, you can start with what is called a non-provisional patent application. So here, you have an idea, you're going to develop it, you decide the time is right to file your non-provisional patent application. And this is the really formal patent application that has to have the black and white line drawings, it has to have the certain sections, and this is typically going to be attorney drafted. You really, if you're serious about it, you should have an attorney draft your non-provisional patent application. Otherwise, you're going to have a lot of difficulty. The non-provisional has to have the claims section. It's going to have the detailed description, all that kind of stuff. So you draft and file your non-provisional patent application, and then it's going to wait in line for 1 to 3 years before examination begins. And why is this? Why is it taking 1 to 3 years? Well, it's the government. The government's kind of behind. You just sort of wait in line until examination begins. And it depends on the type of technology. So when you file your patent application, it gets sent to what are called art units. And so some art units are really, really busy. So for instance, like in things like AI and computers, even though they staff those really heavily, those can get really, really backlogged because there's a lot of people filing patent applications in these spaces. And so those kind of art units, those will probably take 3 years, whereas other things that aren't as invented in as commonly, or there's not as many patent applications filed, it may only take a year to get to examination. Just totally depends on the examiner it gets assigned to, the art unit, all those things. But a lot of people are surprised that it takes 1 to 3 years to get to examination. That's once the examiner picks it up. What they're going to do is do a prior art search, determine whether what is claimed is new and non-obvious over the prior art, and then they're going to formalize the rejections, which is, I'd say in 95% of the cases, there are going to be rejections. It's a natural part of the patent process. So the examiner is going to formalize those rejections into what is called an office action and send that to you. And then you have a period of time where you're going to draft a response to that office action. So you can argue against rejections, you can amend the claims, you can do a little bit of both. And this starts sort of the back and forth with the examiner. A great way to think about the examination process, it's just like any sort of haggling. Like if you go out, you go to a market or something, you go to a flea market and you're haggling over prices. It's the same thing, right? So this is a natural negotiation. And just like haggling, the benefit is that you're going to get the best patent protection possible. So it's important to understand patents are not just a binary thing where you have a patent or you don't. You can really have broad patents that cover a lot of different variations, or you can have patents that are so narrow and so specific that they're effectively worthless, that people could easily design around them, right? And so that's why it's important to go through this negotiation. You want to make sure that one, I mean, sure, it has to be new and non-obvious of the prior art, but you want to be able to have the broadest patent that is just barely new and non-obvious over the prior art. So you get the broadest patent that covers the most variations, that has the most value. So this negotiation, sometimes it can take months, sometimes it can take years. So you file your response, then the examiner does a new prior art search. They may update the rejections, add new prior art, and this could go back and forth 2, 3, 4, 5, 6 times, and it can be a long time in this examination process. But hopefully at some point, you convince the examiner that what you have is new and non-obvious over the prior art. The examiner allows the case, sends you what's called a notice of allowance. You then pay an issue fee, and then a few weeks later, the application will grant as a patent. So that's starting with a non-provisional patent application. And I typically don't recommend this for startups, not a good idea. I recommend the second option, which is the line below here, which is starting with a provisional patent application. So in a lot of ways, it's kind of similar in terms of the timeline. So you have an idea, you decide when you're going to file, and instead of filing this really formal non-provisional patent application, you file what is called a provisional patent application. Now, the provisional patent application, it is just a placeholder. It only lasts for 1 year. It automatically expires at the end of the year. There's no way to extend that term. And that's then when you have to file that formal non-provisional patent application. So why is there a benefit to starting with a provisional application instead of a non-provisional? And so, for instance, you see those red circles. The thing about starting with the provisional, it actually delays you getting an issued patent by a year. Okay, and some people say, well, we don't want that. We want to get an issued patent as soon as possible. But again, it's counterintuitive, and especially for startups, getting an issued patent sooner isn't always the best thing. You want to be able to defer those costs as much as possible, and starting with the provisional is a great way to do that. So one of the things that I like to do with my clients a lot of times to keep costs down is, especially in early stages, people have more time than they do money. And so what they can do is I can coach them on drafting an invention disclosure that then we can formalize. I can scrub to make sure there's not limiting language, make sure it has sufficient support, and then we will file that as a provisional patent application. That's a great way to keep costs low initially and be able to get a high quality patent application that really covers a lot of variations and something that the inventors can do themselves. So we file that provisional application, and then at the non-provisional stage, then we can add new things that have come up that have been invented in that year. So it's a great way to incrementally protect inventions. Another strategy related to this is you'll file a provisional, and then in 6 months, you'll file another provisional with things you've come up with in 6 months, right? There can be a lot of R&D that goes on in a short period of time. If you come up with new inventions, you want to protect those. And then at the non-provisional stage, you can add even more stuff at the non-provisional stage so that you can get 3 incremental steps really cost effectively of priority dates protecting that invention as you're developing it. You can't really do that very easily with the non-provisional patent application. You would have to file a completely new non-provisional patent application, going to have full filing fees, and then you're going to have multiple applications that are being examined at the same time. Whereas starting with the provisional and then at least adding new stuff at the non-provisional stage, that's a really cost-effective way to have all sorts of different variations, and over time, let the product develop, know what you're actually doing, and it's way more cost-effective and really fits in well with the life cycle of startups. So at that point, you file the non-provisional, and then it's pretty much the same. So again, waits in line for 1 to 3 years before examination begins, starts that negotiation with the examiner. There's the back and forth. They send you off section with rejections, which is going to happen almost all the time, expect it to happen. And then it goes back and forth, sometimes 1, 2, 3, 4, 5, could be multiple times. You have this back and forth. Hopefully the examiner realizes that what you have is new and non-obvious, sends a notice of allowance, you pay an issue fee, and then a few weeks later, the application will issue as a patent. So that's a big benefit of starting with a provisional application. It's that flexibility. And so I would say almost standard, I would suggest that startups start with provisional applications. Hey, patent friends, if you want to see the full video that this clip came from, click this box right here, or click this box right here if you want to see a playlist of all the clips from this video. And be sure to like the video on your way out to support the channel. Thanks.